when the state was
Well,
able
it's
to
highly
follow
offensive
up.
when someone lies on you, and it's highly offensive when they try to implicate that you slept with somebody the first day you met with them, and I take exception to it.
All right. Well, Ms. Willis, she'll have the opportunity to explain all of that when it's the state's turn to ask more open-ended questions.
Yeah.
Ms. Merchant.
Thank you, Judge. So again, my question was, you all met at that conference, though, right?
We did. The meeting,
Okay.
he, as I stated, he taught the class. I did not actually meet him when he taught the class. I walked out of the class, and I'm not sure if it was that exact class or we had went to lunch, but we were standing in the vestibule, like outside of the class. Me and Judge Reeves were having a conversation. She had worked at a law firm I worked at back in 1996.
We're getting way afar. I mean, I don't mind her explaining her answers, but I literally just asked if they met at that conference.
Explaining how she met Mr. Wade, which was exactly the question asked by Ms. Merchant. These answers are more than appropriate.
Ms. Merchant, if you want more concise answers, perhaps you could lead the witness.
I will. Thank you, Judge. Isn't it true that you met Mr. Wade October 2019 at the Judges Conference?
He hasn't gotten to the point where Ms. Willis should be treated hostile in this situation.
I think we have.
I very much want to be here, so I'm not a hostile witness. I very much want to be here.
Not so much that you're hostile, Ms. Willis, it'd be an adverse witness. Your interests are opposed to Ms. Merchant's.
Thank you.
Merchant's interests are contrary to democracy, Your Honor, not to mine.
All right, let's
Judge,
proceed.
I would just ask that
we can keep things moving. Ms. Merchant, next question,
Thank you.
please.
Okay, so we've confirmed when you met. After that, isn't it true?
No, I need to explain this, and I think I get to explain my answers. When I met him, Judge Reeves introduced us. He handed me his business card. I'm unsure if I handed him my business card, but we exchanged information. He said, if you ever need any help, give me a call. And he walked to the parking lot.
So after that, you started dating shortly thereafter, correct? I'm asking you to go through 1,000 pages of records. I'm asking if you remember paying for a cabin 6 months ago in Tennessee.
No.
You remember booking a cabin?
I booked lots of cabins.
Did you go to a cabin with Miss Willis ever?
Ever?
Ever.
No.
There's nothing more powerful than the odor of mendacity.
Breaking news, the liberal District Attorney Fani Willis, who went after Donald Trump in Georgia, just got kicked off the case. Georgia's Court of Appeals has just disqualified her from prosecuting the 2020 election case against Donald Trump and his co-defendants. They are citing conflict of interest. Well, no kidding. The court began looking into whether Willis should continue the case after that romantic relationship with the ex-prosecutor Nathan Wade came to light. The court said this: while we recognize that an appearance of impropriety generally is not enough to support disqualification, this is the rare case in which disqualification is mandated and no other remedy will suffice to restore public confidence in the integrity of these proceedings. Yeah, well, she put in there he was making more than anybody else on the staff, and his resume didn't really match up what his job was going to be to go after Trump. There's that. The court did not outright, though, dismiss this case. It will now be up to the Prosecuting Attorneys Council of Georgia to find another prosecutor to take over the case and decide whether to pursue it. That process could be delayed if Fani Willis decides to appeal to the state Supreme Court and tries to get back on the case. President-elect Trump told Fox moments ago, quote, "Whole case has been a disgrace to justice, and that should not be allowed to go any further." Phil Holloway, former assistant district attorney, former Georgia police officer, and legal advisor to Georgia's Sheriff's Department. So you know that state, you know its legal system. Fani Willis, talk to me about what they saw outside of what we all knew.
Well, Harris, you know, the statement or the part of the opinion that you referenced in the lead regarding there's no other remedy that will suffice is, I think, the very best and most important language in this opinion, because the appearance of impropriety, as the courts note, is oftentimes not enough. But this is the case because, look, this is the one that has the elected district attorney, taking lots of taxpayer money, funneling it to her admitted paramour, and then benefiting from that financial arrangement by virtue of all the romantic trips and the getaways and all of those things. So if it's not a direct kickback, it certainly has the smell of potentially a kickback. And her testimony, of course, they said had the odor of mendacity, which means that nobody believed her testimony when she tried to explain this. But it's more than the conflict of interest with Nathan Wade. This is also about what we call forensic misconduct. There's out-of-court statements where Ms. Willis goes into the well of a local church here in Fulton County, Georgia, which is full of potential voters and full of potential jurors, by the way, I might add. And she maligns and impugns the various defendants out in a very public way. Prosecutors are not allowed to do that. They're not allowed to try their case, so to speak, on the courthouse steps, nor in the well of a church. This is something that was actually predicted. I predicted this outcome. She can appeal it to the Georgia Supreme Court, but I've got news for her. The Georgia Supreme Court is not going to take this case. It's discretionary. They don't have to do it, and they won't. They are going to affirm the Court of Appeals, and this case is going to be effectively over because the Prosecuting Attorney's Council of Georgia is not going to be able to find another DA if they wanted to, Harris, that wants to take this monstrosity.
Is that the only issue with this case? Because, you know, that can change. People can come in and out of those jobs and so on and so forth. Is there anything else inherently true about this case that would get it dismissed at this point?
The former president, President-elect Trump, has asked the Court of Appeals to dismiss the case. And of course, in this opinion, they said, look, this is not, this doesn't rise to the level of dismissal. That's a separate issue. Now, there's other requests being made of the courts on the grounds of presidential immunity and that sort of thing. But this effectively kills the case, Harris. It's an orphan indictment. It's now going to be indictment without a prosecutor. And the Prosecuting Attorney's Council is not going to find any other DA that wants this. Look, they'd have to shut down their whole office, and they'd have to, just for this case, basically shut down all of their operations. They would have to redo everything that she did and try to fix the problems that she created. It's not going to happen.
All right, I want to get to this.
All right. Welcome back Inside the Law, everyone. I'm your host, Philip Holloway. We have a lot to talk about. Thank you for joining me here. Those of you who are watching live, and of course, as well on the replay live, it's a little after 3:08 p.m. Eastern time on a Thursday. And it's truly remarkable to see everybody joining because this is truly a remarkable development in the, I call it the Fani Willis versus Donald Trump racketeering case, Fulton RICO case, whatever you want to call it. This is, in large part, this case is the breaking news story. This is the criminal law news story that this channel sort of was born out of. If for those of you who remember, we started this in the spring of 2024, right about the time this issue was getting hot. Now, of course, you know, here Inside the Law, we take you inside the real justice system, and we use the cases that are in the news as the vehicle for doing that. And we do it because we want to learn, okay? This is not the channel that just talks about politics or even political / legal stuff. We talk about everything that's breaking in the news, things that are active in the news cycle so that we can learn how the system really works in real life. But look, this is a big day. I was going to say it's almost like Christmas time here Inside the Law, but guess what? It is Christmas. This is a big, big deal. Okay. And before we bring in our friend Rachel Kaufman to help us break all this down, let me just sort of set the stage, you know, what happened. Okay. So back in early December 2024, we were supposed to have oral argument before the Georgia Court of Appeals on this very issue, the issue of whether or not Ms. Willis should be disqualified, booted from the case, so to speak. And then a few weeks beforehand, we got like a 1-page order, one sentence actually order from the Court of Appeals that said oral arguments canceled. It didn't give any reason. And I have said here and elsewhere that I thought that probably meant that Willis was about to lose. I thought that meant, reading the tea leaves, Willis was about to lose, and they didn't need to hear an oral argument from anybody because they already had, a majority of the judges on this appeals court panel. And lo and behold, that was correct. I said, look, they would not have taken away Ashley Merchant and all the other lawyers, who represent these defendants, would not have taken their day in court away from them if they were going to rule against them. And lo and behold, that's what has come to pass. And so today, as you've seen from the introductory video, the Court of Appeals has done just that. In a 2-1 ruling, a 3-judge panel has said that Willis is in fact disqualified, and not just her entire office is disqualified. With that being said, let's go ahead and welcome here inside the law our friend and yours, Rachel Kaufman, who is, of course, just like you guys, spending her first holiday season with us here inside the law. She's some of you have come to know and love Rachel from all of her work as it pertains to Fulton County in general, but the YSL case and, of course, the Fulton County Jail and all of those issues. But look, this, Rachel, is right in your wheelhouse as well in terms of Fulton County, because what we've seen is, Willis is just not having a very good last few weeks, is she?
No, and it's the accumulation of a lot of really, questionable, bad, I would call it bad, decisions that she's made over the course of her first term as a district attorney. I mean, we kind of watched it was more of a flail for a long time. Now it's just kind of hit the ground finally, where it's all catching up to her. She doesn't seem particularly, taken aback by the reality of what she's done with her office between the RICO case against YSL and this case. I mean, she's really, really wasted taxpayer money, and in an office with an overcrowded docket, she's just wasted the time of causing a ripple effect for so many criminal defendants in Fulton County. I mean, you called this though, Phil. I remember when we were talking about this, you knew that the reason that they put off the oral argument on this is they apparently didn't need it.
No, they didn't. And speaking this opinion that I just pulled up here to share with everyone, it's got today's date on it, so it's hot off the presses. I think maybe, just maybe, I'm the one that officially broke this news to the public this morning on X fairly early in the day, because as soon as I posted about it, posted a thread actually where I put a lot of this opinion out there, I started getting, my phone was blowing up, media requests and all kinds of things. And I had turned a lot of them down. I said, look, no, because I'm going to come here inside the law and we're going to do this show on this channel, because we're going to talk about what this ruling, what it says, what it means. And I want you to help me with this, Rachel, because I can't do it all. You're smarter than me. So I just will start out by pointing, I've highlighted some things I accidentally highlighted and I didn't mean to, but we'll get into that in a minute. But I wanted to start out by pointing out this, this shows that the Court of Appeals is broken down into divisions. And I don't know how many judges there are on the Court of Appeals in Georgia. There's certainly more than 3. Let's just say it's 15 for lack of a better number. That would be my just guess. You get 3 at a time, usually, that rule on any appeals case. And at the very top, it says motions for reconsideration must be physically received in the clerk's office within 10 days of the date of this decision, which of course is today, December 19th, 2024. But I thought maybe she was going to ask for reconsideration, but she didn't, Rachel. You know what she did? I was on another program, Megyn Kelly's show earlier today. It'll air a little bit later, I guess, streaming. But Ashley Merchant pointed out, because she was with us, she pointed out that Willis has already filed a notice of appeal with the Georgia Supreme Court. Rachel, a lot of people are asking, I'll let you explain it. Does the Georgia Supreme Court have to take the case?
No, my understanding is it's a discretionary appeal. On that note, really quick, I just want to comment on the fact that her appealing this ruling is wasting even more resources. I imagine, her office is going to be putting too many resources back into holding on to this case that can't even really be prosecuted at this point and won't be prosecuted for the next 4 years. I just don't understand. I cannot stand when people in power double down instead of realizing when it's time to step back and do what's right. You lost.
Yeah. Yeah. Well, look,
my God.
So yeah, it is discretionary. And for reasons that we'll get into, I want to go through the high points of this ruling here. But I think this opinion is pretty well buttoned up tight. And by that, I mean, I don't think the Supreme Court of Georgia is going to be very interested in taking this case, because I think that for reasons we'll get into here in a minute, they got it right at the Court of Appeals. Now they might, though, the reason that they might take it would be if they wanted to just underscore what they say in this ruling, which is that prosecutors need to exercise their discretion and do their job basically with an eye towards the public interest, not their personal interest. And I'm sort of, that's my words, not theirs, but it's kind of theirs. But the Supreme Court has an opportunity here to emphasize what prosecutors are supposed to do and how they're supposed to go about their job. Interestingly enough, I wanted to point this out because people are asking this question already. And by the way, thank you for those of you who are, I'm monitoring the chat. I'm doing my best to try to keep an eye on it. And I will do my best to get to the questions. And some of the things that we're going to say may answer some of those questions, hopefully so. But look, these are the people that are, of all the defendants in the case, these are the ones who actually took up the case on appeal. Obviously, Michael Roman, who was Ashley Merchant's client, but David Schaefer, former head of the Republican Party in Georgia, Robert Cheeley, Mark Meadows, the former chief of staff at the White House, of course, President-elect Trump, Kathleen Latham, Rudy Giuliani, Jeffrey Clark, and Harrison Floyd. So those are the only ones actually filed this motion on behalf of Michael Roman. She's the Aaron Brockovich of it all. And the other defendants joined in her motion and, of course, also participated in the appeal. Interestingly enough, all of the defendants who are named on the indictment, and I don't have it in front of me to tell you what all of their names are, but even if they didn't participate in this, they win too, because if she's booted off the case for all these people, she's booted off the case for all of them. I mean, Rachel, I don't know how you see it. I just don't know. I don't know why they didn't all just adopt and join in Ashley's motion.
Yeah, I'm not sure what the strategy would have been there. I know there's a few individuals that took pleas, which I bet, now I guess they're probably nearing the end of their sentence. But aside from them, no, I don't think she doesn't get to handle any of their cases. But after you have such a public fumble, I mean, I think calling it a fumble is a nice term. It's more like an interception. I mean, you really screwed up for your team. I'm not on that team, but I mean, looking at it from just a neutral perspective, I mean, she really fumbled the ball, and she's still saying, "Throw me the next one," and it's like, no, like at some point you fumbled so much that why would you be allowed to continue to do this? I mean, she's lucky, in my opinion, given the way that she testified on the stand when you were showing that at the beginning. I kind of forgot just how out of control she was when she was testifying at that hearing in front of Judge McAfee. She
was really defiant, wasn't she? She was really, just her overall demeanor, in my view, came across as if it was just obvious that it was personal to her.
She says, "I'm not hostile. I want to be here." She knows that's not that's not what they're looking at to determine whether you're hostile or not. And the truth is that you are acting quite hostile. But the whole thing, she's lucky she has her bar license and she got reelected, and I mean, those are things that I think if you're not from Fulton County, it's hard to even understand how that would happen. I wish somebody ran against her that was really involved in the Fulton County criminal justice world, because I think that it would have been a better fight. I mean, I do think that Ms. Kramer was,
Well, look, there's not a lot of takers, really. Fulton County is overwhelmingly blue, and again, this is not a political show; it's a legal show. But this, I mean, part of the issue here is that the courts and I'm sure the public understands that. Look, we've got crime in this county. We got, or in the city, we've got serious crime. You got murders. You got assaults. You got all the human trafficking and all the really ugly stuff, not to mention all the problems at the jail that we've gone into on other streams here, you and I. But this is how she wants to spend the resources of the DA's office, which are not unlimited. And so in the last election, Courtney Kramer picked up like 31% of the vote in Fulton County, running as a Republican against Ms. Willis on the Democrat side. Donald Trump, by way of comparison, pulled, I think, 27 or 28% in Fulton County. So on a bipartisan basis, the voters in Fulton County, I think, disapproved, at least to some degree, in how she's running this office. And it's not just this case, it's the YSL and all this other stuff. But let me talk about this. In the opinion here, it talks about pursuant to a granted interlocutory application. Rachel, can you explain what an interlocutory application or interlocutory appeal is for?
Yeah.
And we've talked about this before, but just to refresh our memory.
Yeah, so similarly to whether the Supreme Court is going to accept Fani's application for an appeal, when a trial court makes a ruling on a motion, it's oftentimes discretionary whether the trial judge allows you to take the case up and request an interlocutory appeal. The Court of Appeals did not have to take it. And the trial judge, Judge McAfee, did not have to allow the defendants to put the entire case on hold while they explored his ruling on their motion before them. So she filed an interlocutory appeal, meaning that she went to the Court of Appeals with the hopes that they would take the case and hear it with and put everything else on hold until it gets resolved. It was worth it.
I mean, and the really unusual thing about it, look, interlocutory appeals, like I said, they're not that common. Judge McAfee, the trial judge, he had to approve it. And even though he approves it, there's no guarantee that the Court of Appeals is going to take the case. So you got to jump through some pretty big hurdles in order just to get this case up on appeal. Normally, in the ordinary case, and this certainly is no ordinary case, you've got to wait until the end of the case, after maybe a jury verdict. And if there's a conviction, then you take everything up on appeal, including these pretrial issues. But this is one of those things where, and I'm glad it turned out this way, because this is so important. If you've got a prosecutor who shouldn't be on the case, and to Judge McAfee's credit, now he didn't order her removal, but he did set the stage for this, because he made the factual findings that we'll get into. And he's the one that said, look, I'm not claiming to know it all. I'm not claiming to be, perfect in my judicial reasoning, because this is an unusual case. We don't have much in terms of, predicate for this. We don't have any precedent for it, is the word I was looking for. And so, yeah, I'm going to let the parties take my ruling up on appeal. And a lot of judges are too prideful to do that. And to his credit, he said, look, I might very well be wrong. And if I'm wrong, here's your chance to take it up and let the Court of Appeals decide.
He's a dream judge. I appreciate his humility. Many of the judges in Fulton County would have absolutely just denied the request for an interlocutory appeal. I do think that he set the stage. I mean, I think he calls it like he sees it.
Yep.
And I think he does it in the most neutral way possible. What makes it really impressive to me is the fact that he was actually a member of that office for several years. Fani was his supervisor. Adam Abadi, who was handling that hearing, I mean, that was someone that they came up, they're around the same age and came up together in that office. And he maintained his composure and professionalism despite what was going on the stand. I mean, you could tell that Fani was trying to use the fact that he had been her subordinate for so long to try to kind of intimidate him. And I was just really impressed by everything that he did in the case. My Rottweiler's name is Leroy, and he's trying to eat. He's just Leroy. You want to say hi to everybody? Say hi. There he is. Okay, that's Leroy.
All right. Well, Leroy will appreciate that we've got, so they start out in this opinion by framing the issue, the appellants, which are Ashley and company. They assert numerous grounds to reverse the trial court's order. That's McAfee's order, including arguing that the trial court, McAfee, imposed an improper remedy. That was basically tossing only Nathan Wade off the case, essentially. And the other side, Willis's team, argues that the trial court should, the Judge McAfee's order should be affirmed. That means it should be upheld in its totality. So we got two pretty much diametrically opposed arguments here. This right here is really key. For those of you who like inside baseball, well, here's some. The state has not filed a cross appeal asserting that the trial court's finding of this appearance of impropriety should be reversed. In other words, you know, Ashley and crew, they appealed the order, but Willis could have also appealed from the order. And it sounds strange that they both could be appealing, but Willis could have appealed. It's called a cross appeal. She could have filed an appeal saying, you know, look, Court of Appeals, Judge McAfee was wrong. He should not have found, based on the evidence presented to him, he should not have made a finding that there was an appearance of impropriety.
I bet they're kicking themselves on that now. I mean,
yeah, well, that's right.
They're not used to it. They're not used to filing cross appeals. So they're looking at this like, damn, we should have done that.
Well,
not
they didn't.
But
yeah. And if you don't bring it up, you waive it. Okay. And if there's no appeal on it, then the Court of Appeal, the issue is not properly before the court, meaning that they don't have the ability to rule on it. So because that issue was not appealed, then the controlling order for purposes of this analysis is the trial judge, Judge McAfee's order. And Judge McAfee found there's an appearance of impropriety. So they go on to say, so whether the evidence presented to the judge adequately supported that, it's not before this court. So they're going to determine whether the remedy that's kicking only Nathan Wade out, if that was sufficient. And they go on to say, we conclude that the trial judge was wrong, and therefore we reverse the trial judge's denial of the appellant's motion to disqualify. We affirm, however, the denial of the motion to dismiss the indictment. So we still have an active indictment technically, and we'll talk about that. But the big news is that Willis, as of right now, is off of this. And of course, they go through the history of all of this, and they look back to the in January of 2022, they impaneled at the DA's request a special grand jury. And so there was a motion to disqualify Willis that was, if I'm not mistaken, it was brought by counsel for Donald Trump at the time to disqualify her because there had been an election, as we all know, in 2000. Okay, so we're 2 elections ago now. But in that election, there's a candidate by the name of Burt Jones who was running for and won the office of lieutenant governor in Georgia. So Willis, having served as the quote legal advisor to that special grand jury, around the same time she hosted and headlined a fundraiser for opposition candidate for the candidate opposing Burt Jones in the lieutenant governor's race.
It's Charlie Bailey.
She later identified Jones as a target. Okay. So there was a motion brought to disqualify her and her whole office from the entirety of the case on that basis. And the Superior Court, different judge, not Judge McAfee, but the judge overseeing that.
McBurney.
Yep. Judge McBurney, he said, look, I'm going to disqualify her vis-a-vis Burt Jones, but not all the other potential defendants. And Judge McBurney talked about the DA's partiality naturally, immediately, and reasonably arises in the minds of the public. There the subjects of the investigation necessitates disqualification. An investigation of this significance, garnering public attention, it says it cannot be burdened by legitimate doubts about the DA's motive. It says the DA does not have to be apolitical, but her investigations do. And so the Judge McBurney denied the motion to disqualify her for the remaining defendants and the potential defendants in the case, but it did boot her off of any investigation relating to Burt Jones, because we all know that Burt Jones would have been a defendant in this case, but for Willis having been disqualified earlier for that, clear conflict of interest. Rachel, did I cut you off?
No, but I do, again, at every step, what we've seen here is that somebody has to challenge the ethical decisions of their office in order for there to be a reasonable ethical decision about who to prosecute and how. Unless held to their feet are held to the fire, they'll do everything that they can, even if it's outside of the bounds of what's right. It's just sad that they have to be to bring a DA's office, to the table in this way. It's demonstrative of bigger systematic problems that are going on. You can keep going.
So
depressing.
For those of you who might be just joining us, and by the way, I see 1,287 people live in here right this minute. I really appreciate you spending some of your day with us here inside the law. Please do me a favor, like and subscribe to the channel. That doesn't cost you anything. It would be the greatest Christmas present you could give me if you became a new subscriber to the channel. Rachel Kaufman is joining me. We are, of course, getting into the ruling issued by the Georgia Court of Appeals that tossed Fulton DA Fani Willis from the Trump RICO case. Moving on page 5 of the majority opinion, they reference where we are now, the motion to disqualify following the indictment. After DA Willis spoke publicly in a church service on Sunday, January 14th, 2024, so almost a year ago. It seems like it was just yesterday. But anyway, on Sunday, January 14th, she spoke publicly in the well of a church. The various appellants filed motions seeking dismissal and disqualification on the grounds that, among other things, she had engaged in what we call forensic misconduct, Rachel, which, as you remember, is when DAs, they can't go out in public, certainly into the well of a church before people that in Fulton County who very well could be on any potential jury and start bad-mouthing and trash-talking defendants that they're actively prosecuting. Okay, it's misconduct. It's not allowed. She did it. And it was one of the bases for this appeal. But interestingly enough, they described this, and I misread this originally. And when I looked at this more closely, I realized that the forensic misconduct is not part of this ruling is not based on that. Okay. They described their analysis on this as follow. They look at the trial judge's order, and it's, by the way, they quote it extensively here. They pointed out that the forensic misconduct was not really fully developed. That issue, they were not allowed to fully cross-examine Willis about this issue, and it was never fully developed, and it really just did not make its way into this appeal. But what did make its way into the appeal is that they cite here the trial judge's order. The court finds that the defendants failed to meet their burden of proving the DA acquired an actual conflict of interest in the case through her personal relationship and recurring travels with her lead prosecutor. The other alleged grounds for disqualification, including forensic misconduct, are denied. However, the record right now highlights a significant appearance of impropriety. This is McAfee's ruling. Okay, this is what they're quoting. A significant appearance of impropriety. And that word significant is going to be important here. And it says that it infects the current structure of the prosecution's team. All right. So they go on here in the footnotes, and I like to look at footnotes. The transcript reveals that the trial court precluded cross-examination of the DA about matters related to forensic misconduct, and goes on to say that the record before us, which is all the transcripts, contains no authenticated recording or a transcript. It was never introduced into evidence at the hearings, and the appellants do not assert on appeal that the trial judge made a mistake by limiting their cross-examination on that issue. So they kind of let that issue fall by the wayside, right? So we're just left with Nathan Wade. Rachel?
Yeah, so, I actually felt like if I don't really know why he precluded them from bringing that stuff in, because I felt like what she was doing at the church speech was actually, equally problematic, if not more, to her hiring Nathan Wade and engaging in the relationship that she engaged in with him and spending all that money on him and then possibly getting kickbacks. She was bringing, not only just talking about the defendants publicly, but she was really bringing race, the racial differences between herself and most of the defendants into play in a way that was incredibly unethical, given that she's not supposed to be making any such comments about defendants, let alone, the racial tensions that she perceives between them. I thought that, that would have been, had they gone forward with that, and had they, had the defendants actually, objected or called attention to the fact that Judge McAfee did not allow that, I think that could have been another issue worthy of removing Fani's entire office from the case as well.
I could not agree more. I thought that was a significant issue. I thought that alone would have been enough to disqualify her. But nevertheless, the winning issue was this one. And they, I think they're still quoting the Judge McAfee's ruling here. On November 1st, the DA hired Nathan Wade to serve as special ADA and lead the investigation that produced the indictment. He was under a contract. For those of you who might be new to this story, by way of background, as they point out, the contract allowed a $250 hourly rate. This was a individual who was not in the DA's office. He's not an assistant district attorney. He was in private practice. And as we now know, was in a romantic relationship with Willis herself. And so you have a number of issues, and I'm surprised, and I don't really know why this didn't get more traction. I don't like these so-called no-bid contracts. If you're going to do a contract with the government's really under a fiduciary obligation as stewards of our taxpayer money to seek out the best contractor, the best qualified contractor who's going to do it for the best value. In other words, maybe not necessarily the lowest price, but to get the most bang for the taxpayer buck, so to speak. No pun intended.
I know. I was like, hold on. Oh man.
I stepped right into that one as soon as I said it.
But okay.
Yeah, but we want these government officials to award contracts in a way that protects the government coffers, right? And so this issue bubbled into the case, and between October and May, the DA and Wade traveled together on 4 occasions that resulted in documentable expenses. The first included an extended trip in October 2022 to Miami and Aruba and a cruise. Now, bear in mind, okay, they are involved in a romantic relationship. She's steering taxpayer money to him. He, in turn, is spending money on her, going on all. And so, look, people look at this and say, is that an actual kickback, or is it merely the appearance of a kickback? I guess you can have a discussion about that. I'm interested to see what you folks think in the comments. Was that a kickback? But the court doesn't really get into deciding that. But he does point out, Judge McAfee does, Wade initially covered expenses for the October 2022 trip, including $5,223. In December 22, they flew to Miami for another cruise, for which the DA paid a whopping $1,394. So Wade purchased passage on the cruise along with other expenses totaling and I don't, this seems very low to me, $3,684. But anyway, and then in March of 20, they went to Belize, where Wade covered resort and restaurant. And look, this is all based on their testimony as far as who covered what. And, we know what the judge has said about the testimony. He doesn't believe it necessarily. But anyway, Wade covered the resort and restaurant expenses in the amount of $3,000. In May of 2023, they went to Napa, where Wade covered airfare, lodging, and Uber rides. They described a number of day-long road trips to Tennessee, Alabama, South Carolina, North Carolina, and other parts of Georgia. They admitted to dining out on multiple occasions. And of course, there was the issue of reimbursement, where the DA testified that she reimbursed Wade in cash for the Aruba trip, which she estimated cost around $2,000. He points out the reimbursement may be unusual, and the lack of documentary corroboration is understandably concerning. Rachel, do you think that's concerning?
Given that their office in their forfeiture unit, I'm sorry, I'm having crazy pregnancy brain. My words just don't come to me. But in their forfeiture unit, when you can't demonstrate exactly where the money comes from, they try to take it from you. So it's just funny to me that it's acceptable for her to have cash laying around that she can't explain where it comes from. I remember her telling Ashley Merchant, "I don't use checks, ma'am. I don't use checks." She just uses cash. It's all under the table. And again, we're odor of mendacity, very strong. I don't believe it at all. I don't believe it at all. And back to what I've been saying since the beginning is that we have real problems in Fulton County. In Fulton County jail, people are languishing and dying in there. Meanwhile, they're taking these trips every other month when her office needs to be focused on clearing these cases. She's busy gallivanting around with the money that she paid him, and she had enough staff to have handled this case without his assistance. He also had absolutely no RICO, I don't think any felony prosecution experience also. So
the DA herself acknowledged no ledger exists other than a, quote, best guesstimate, and there's no way to ask her to be certain that the expenses were split evenly. The trial judge, Judge McAfee, was impressed by the fact, apparently, by the way, when I say impressed, he found that it was significant anyway that the DA was not financially destitute throughout this time or was in any great financial need. She testified her salary exceeds $200,000 per year. And so he just seemed to factor that in and think, well, okay, this is not really evidence of a kickback per se. All right. So the Court of Appeals, moving along, says that the trial court found, quote, insufficient evidence of an actual conflict of interest, but it also concluded, and by it, we're talking about Judge McAfee concluding, the record made at the evidentiary hearing established that the DA's prosecution is encumbered by an appearance of impropriety. This appearance is not created by mere status alone, but comes because of specific conduct, and it impacts more than a mere nebulous public interest simply because it concerns a public prosecutor. So let me get into what they're getting at here. They point out later in the opinion, and I don't want to get too much ahead of ourselves, they point out that the typical in Georgia law, what's typical is that a conflict of interest, if it's an appearance of one, actually, that's oftentimes not enough. But because this is a particularly egregious case that she brought upon herself by virtue of her own conduct, it becomes something, it maybe falls into a category by itself where it will require, if the circumstances justify it, it will require a recusal from the case where ordinarily the mere appearance of an impropriety would not. All right. So I don't want to read to you guys all of Judge McAfee's opinion, but these footnotes are interesting as well. The DA and Wade testified their personal relationship ended sometime in summer of 2023. You remember there was this witness, Robin Yurdy, whose testimony raised doubts about those assertions.
Well, and then also she showed up when her daughter was being arrested at that traffic stop. When Fani came to her rescue.
It seems like maybe
he was right by her side. He was right by her side. Furthermore, just insider information from people who work in that DA's office would say that Nathan Wade continued, despite being off the case, that he continued to have access to the Fulton County DA's office and was regularly there after this.
And remember, they had this cell phone testimony that Trump's attorneys put forward using the cell phone expert regarding where Nathan Wade's phone was and all this. And if you remember, we had that scenario set up where they were able to show using cell phone data that there was some overnight visitation happening. And then Ashley Merchant questioned Willis about cohabitation, and she was essentially called a liar for saying that she cohabitated. And of course, Ashley pointed out that using Georgia's own legal definition of cohabitation, it simply means shacking up under the same roof one night, right? That would be sufficient to qualify as, quote, cohabitation under Georgia law. This is probably the biggest part, and this is one of the reasons that this case is really what it's going to be famous for. However, it says, McAfee says, an odor of mendacity remains. The court is not under an obligation to ferret out every instance of potential dishonesty from each witness. Yet reasonable questions about whether the DA and her hand-selected lead special assistant DA testified truthfully about the timing of their relationship further underpin the finding of an appearance of impropriety. And look at this, Rachel. This is the Court of Appeals footnote. They dropped this in a footnote, and I promise you, sometimes the best stuff is found in the footnotes. Mendacity means untruthfulness or tendency to lie. And they cite Webster's Encyclopedic Unabridged Dictionary of the English Language.
Well, so I think I told you this too. What I've learned about Scott McAfee is that he has a law clerk that does his civil stuff, but my understanding is his law clerk doesn't touch his criminal stuff. So this is him writing all this, by the way.
There's nothing more powerful than the odor of mendacity.
And that's true. There is, it is a very, very powerful, if it exists, it's powerful. And it's an odor, if you will, that infects every aspect of things. And this is why the appellants argued that the prosecution's case and their whole team, quite frankly, was structural. At this point, it became structurally unsound. Does that make sense? Meaning that, it just can't survive, and it just can't go on the way that it currently exists.
It poisoned it.
Yeah, poisoned it forever. All right. Let me make sure I didn't take this off the screen. Okay, I didn't. I thought I might have.
Oh, yeah. So I'm seeing from Gladiator Girl real quick. I also want to mention this. I'm not sure if we've discussed this before, but apparently, so there's a new DA that's taking over in Cobb County. She beat the incumbent. Her name's Sonia Allen, and she is one of she's been in Fani's office. Apparently, Nathan Wade has now been hired by Sonia Allen of the Cobb DA's office to do all of the hiring and firing of prosecutors in that office. I don't know if you saw the Linda Dunikowski thing where the lady who handled the Ahmaud Arbery case who was like attorney of the year, was not welcomed back. Nathan Wade, who I don't know what kind of experience he has with staffing, but he somehow was able to go. I don't know how he gets these jobs.
Well, look, I know. I mean, I've got a pretty good idea how he got this job with Willis. I mean, he did the hiring and firing for Willis's, quote, transition team. And by the way, before I get too much on a tangent, why in the hell do these DAs need transition teams? We're not talking about the White House. I was a prosecutor. I was I know that it's not like when a new DA comes into office, you don't need a bunch of transition stuff. You don't need to have transition attorneys like this. You don't, all you got to do is show up for work on January 1st and you're the DA, right? And if you want to make some personnel changes, make them. If you don't, or change it as you go. It doesn't require a whole lot of, I mean, obviously there's a little planning, of course, but you don't need to have these transitions that are so pretentious, like they seem to be.
Well, that's what Nathan Wade is, basically. He seems to come in and take on roles that are completely unnecessary for money that he probably doesn't deserve.
Anyway, we could do a whole nother stream on this, and maybe we will. But anyway, the appellants, they go on to point out the Ashley and company contend that the trial court's failure to disqualify Willis was erroneous in light of the finding that there was this significant appearance of impropriety. Okay, this word significant is important because it's not like a mere garden variety appearance of impropriety. It's a significant one. So there's apparently a difference between those two types of appearances of impropriety. In the appellant's view, the trial court's forward-looking remedy, which is firing Nathan Wade and then, moving forward from there, it did not cure the already existing appearance of impropriety and the, quote, odor of mendacity. Based on the fact findings of Judge McAfee and the state's failure to cross appeal, the finding that there was a significant, and see, they put the word significant in quotes here. That means something. They said they agree. So if merely getting rid of Wade was not enough. So go ahead. Sorry.
When Judge McAfee kind of issued his order saying either Fani, you can remove yourself or you can remove Nathan Wade, I almost felt like that was like a parent to a child saying like, you can take responsibility for what you did, or you could try to take the easy way out. And that's what they're saying. It wasn't enough to remove this appearance. It's just funny that she tried to take the easy way out.
They, not surprisingly, the Court of Appeals turns to Georgia law to examine this issue. And they correctly point out, and I'm glad they put this language in there, we must examine the particular facts and circumstances of each case. There are some general principles in mind, and they look to this old case from 1981 involving called Bloomfeld versus Borenstein. The name's not important. And this actually deals with the disqualification of a private attorney, not a DA. On the one end, where justification is always justified and in fact mandated, is the appearance of impropriety coupled with an actual conflict of interest. Okay. Now, on the other hand, I'm going to skip ahead. At the other end of the continuum is where there's an appearance of impropriety, but it's not based on anybody's conduct. That would be insufficient grounds for disqualification. But in the middle, they point out there's somewhere in the middle of this continuum is where there's an appearance of impropriety based on somebody's behavior. And that somebody we're talking about here is Willis and others on her team. So they look with all that in mind, they look at the remedy in the context of a significant appearance of impropriety. Okay. In our justice system, the DA represents the people. This is where they really, I think, take her to the woodshed. In our system, the DA represents the people of the state. The responsibility of the public prosecutor differs from that of the usual advocate like me and Rachel. We're just usual advocates. Her duty is to seek justice, not merely to convict. This special duty exists because the prosecutor represents the sovereign, which is the state, and it should exercise restraint in the discretionary exercise of governmental powers. Therefore, the district attorney is more than merely an advocate for one party and has additional public professional responsibilities as a public prosecutor to make decisions in the public's interest. The public's interest, not the DA's interest, but the public's interest. In the district attorney's role as an administrator of justice, he or she has broad discretion in making decisions prior to trial about who to prosecute, what charges to bring, and which sentence to seek. Rachel, what are your thoughts on that? That's pretty lofty.
I think that every prosecutor should have to put their hand over their chest and read that out loud in court before they prosecute for the day.
Yeah. These considerations take this case out of that continuum we just discussed involving the appearance of impropriety, where the conduct of private counsel and a client's interests. So it takes it out of that general area. And this is why when they call it a significant appearance of impropriety, that word significant means that it's, there's a different analysis that would apply to it. After carefully considering the judge's findings, we conclude that the judge made a mistake by failing to disqualify Willis and her entire office. And we pause there, Rachel. If the district attorney herself is disqualified, why couldn't just another assistant DA pick it up and run with it?
I guess it's the same reason that we're allowing for transition teams, that I guess if you're loyal to your boss and your boss is the problem.
Not only that, if the assistant DA doesn't have any authority to act as a prosecutor except that flows from the elected DA herself, right? So their authority is, if the DA doesn't have the authority, the assistant DA can't have the authority. So the remedy crafted by the judge to prevent the continuing or ongoing appearance of impropriety, specifically getting rid of Wade and only Wade, did nothing to address the impropriety that existed at times when she was exercising her broad pretrial discretion about who to prosecute and what charges to bring. While we recognize that an appearance of impropriety generally is not enough, this is the rare case in which disqualification is mandated and no other remedy will suffice to restore public confidence in the integrity of these proceedings. And they drop a footnote number 4. Let me go down to that and see what that is. Let's see, footnote number 4. Maybe here it is, right in front of me.
I'd say this is pretty. It's a pretty foolproof decision where, like, even if the Supreme Court were to take this up, what does Fani think's going to happen? I mean, this is pretty. How would the Supreme Court reverse this?
Yeah, I mean, again, this is why, and I don't think they will.
No, me neither.
I don't think they will, because look, the personality, if you will, of our Supreme Court as well as I do. They're pretty, when it comes to, let's just say, the behavior of people involved in the justice system, they're pretty strict, right? They have disbarred lawyers who the state bar wanted to give like a warning to or something like that. They take this stuff pretty seriously, and I just don't see them. I don't see them taking the case unless they want to underscore that public prosecutors are supposed to work in the public interest, and that's the only reason I think they would take it.
Yeah, but I mean, again, like, what happened here is pretty clear. How can they now go back and somehow justify somehow saying that allowing her to stay on the case would be okay in light of the significant appearance of impropriety? I think it's a done deal here. Very well written opinion.
They say, as we conclude that the DA is wholly disqualified from this case, the assistant district attorneys whose only power to prosecute is derived from the constitutional authority of the DA who appointed them, likewise have no authority to proceed. Now they go on to dismissal, and I won't go into this too much, and because they really don't. They basically say that's just a separate issue. They say that there's just not been enough fleshed out here that would even get to whether or not this indictment ought to be dismissed. They do say this is the rare case in which DA Willis and her office must be disqualified due to a significant appearance of impropriety. We cannot conclude that the record also supports the imposition of the extreme sanction of dismissal under the appropriate standard. So the indictment is, it may be on serious life support, but the indictment is still hanging out there. So let's just fast forward and let's say, Rachel, the Supreme Court upholds this or doesn't take the case, and so Willis is her appeals are exhausted on this. What happens to an indictment without a prosecutor?
Well, I think it's what's happened to the attempted prosecution of Burt Jones? And the answer is nothing.
You got the prosecuting attorney's council, which is a state agency, and whenever whenever the DA or even any kind of prosecutor says, "Look, we have a conflict of interest. We're going to bow out of this case," and it happens all the time for all kinds of reasons. I saw one the other day where an administrative support staff person in a prosecutor's office got arrested for DUI. And so that office would normally be the prosecuting office, but they said, we got to bow out. And the prosecuting attorney's council appoints somebody else to do it, but they don't have to appoint somebody else to it, but it's kind of commonplace. But then you have cases like this where the DA gets booted involuntarily. In either case, it's an indictment without a prosecutor or the prosecuting attorney's council. They have their own independent prosecutorial authority. They can say, we're going to exercise our discretion and not prosecute, and we're just going to dismiss this indictment. They could do that. They could at least try to find another prosecutor in the state of Georgia. But Rachel, can you think of any reasonable, rational, sane district attorney anywhere in the state of Georgia that would want to take this case, keeping in mind they would have to probably go back and start from the very beginning because of the mess that Willis has made?
It's an easy lob to me. No. No way.
Melanie, I meant to get to your question earlier. Thank you, by the way, for all the super chats. That's what helps us continue to bring this content out and gives us, the ability to bring new and better content to the channel. So thank you very much for Melanie and your super chat and everyone else's as well. Melanie asked the question, is it common for an outright removal? Well, that's pretty uncommon, but as opposed to just tossing it back to McAfee. Well, if you have to understand this, McAfee made his ruling. He said that Willis can stay. The Court of Appeals said, no, she can't. So absent any further appellate successes, at some point, the trial court, Judge McAfee, will get this case back. There's something called a remititure where they send it back to the trial court, and the trial court is then obligated to proceed in accordance with the appellate court's rulings, if that makes sense. So they basically said, no, Judge McAfee, you're wrong. So we're going to reverse you and issue a different ruling. And then whatever's left of the case, if anything, can go back to Judge McAfee. I hope that answers the question, but thank you very much.
And really quick, there's a lot of people in the comments who understandably, if you don't work in Fulton County, just kind of think that Judge McAfee was weak or somehow, like I read, had loyalty to Fani Willis. What I can tell you is that there is not a Superior Court judge in Fulton County who would have just removed Fani and her office from the case. Not one of them.
Well, and I'll say this about McAfee, if it weren't for the factual determinations and the factual findings made in his ruling, there would have been nothing that the Court of Appeals could have hung its hat on to reach this result. So if it weren't for, maybe, it's like an umpire, you call balls and strikes. Sometimes you're going to get it wrong. I don't pretend to know what was in his mind when he came up with his rulings or when he wrote the things that he wrote. All I know is that he gave the defendants in this case a written order with factual findings that was, it essentially gave them all of the ingredients they needed to bake this cake. It didn't give them the cake, but it gave them all of the ingredients that they needed, and they were able to craft it on appeal and be successful. And a lot of judges would not have done that. They might have just said, without explanation, they could have just said, motion denied, let's move on. And then to McAfee's credit, this is why he deserves a lot of credit for agreeing to let them take the case up on a pretrial interlocutory appeal in the first place. Most judges would not have done that.
Yeah. So, most judges are not humble, but they're also spineless. So they'll making the tough decisions, calling the balls and strikes with all the public pressure around them. I'm noticing, I was thinking about Judge Whitaker, Krause, Glanville. If you watch these judges, you're just going to see a pattern of behavior that feels like they're unwilling to do the tough thing. And unfortunately, that's how judges stay judges. I don't like
So,
it either.
So this comment just caught me. So why wouldn't a lot of judges do that? I presume that the commenter is referring to when we said most judges would not have allowed the pretrial appeal. And I don't think we're bypassing it because we've talked about it a lot here inside the channel. We did shows, entire shows on the issue of the interlocutory appeal. The short answer to that is that most judges, they will not permit pretrial appeals because they don't like to admit they got it wrong sometimes. McAfee, I think to his credit, says, I might very well be wrong. This is the best answer, and I think this is right. But look, you folks take it up on appeal. If the Court of Appeals reverses me, fine. We don't have any precedent that I'm going by. I'm making this up as I'm having to make it up as I go along. I'm in unplowed ground here. And so I think that most judges would just simply, out of pure pride, would say, no, we're not going to let you appeal it. And so that's why I say he deserves some credit for that.
Yeah,
that's the best answer I can give you.
Why wouldn't they toss Fani initially? Because they don't want to be the one in the paper tossing the DA elect in Fulton County, in a liberal county that voted her in. There's a lot of that goes into every decision that they make. I talk about this a lot. I was in a courtroom the other day and it was packed, probably 50 cases on the calendar. If there's nobody in the courtroom, I feel like I have a better shot with the judge of doing something that may be less popular than what a tough on crime electorate would like to see. But when everybody's watching, they're going to tread a lot lighter, and they do. And it's for optics. So that's why.
Look, I mean, I predict that in the next 4 to 6 weeks, I predict that this entire appellate effort will be over. I maybe sooner than that. This is not quite over yet because Willis does get to appeal. And then of course, assuming that appeal is unsuccessful, we got to see how our predictions play out as far as the prosecuting attorney's counsel and whether they are able to or willing to let another judge take a look at this, or another DA consider prosecuting. My best prediction, and I'm pretty good on my predictions on this case. I predicted today's result. But I predict that this case is effectively over. I don't think that we're going to have any future litigation in a trial court related to this Donald Trump racketeering case. Rachel, do you have any predictions on that?
No, I don't think the Supreme Court's going to take the case, and I think it's going to, die on the vine. And I think that, with Donald Trump coming back into office, she's got to be really careful.
Well, look, I don't know what else we can really say about this other than, we'll see. I'm certainly, I think that the Court of Appeals reached the right result today, and this was a little bit, like Christmas come early. Speaking of Christmas, Rachel, what are you doing for Hanukkah? You going anywhere? You got any big plans?
I can't go anywhere. Maybe to the hospital. I've been joking that I was in court like all week this week. It was my last week of court. I've not been able to wear a blazer because even the stuff that I bought for pregnancy doesn't fit. I sent you a strange picture earlier today. I getting off the couch is hard.
Let's just say, folks, Rachel is very, 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 very pregnant.
Yeah, you can see it in my face, and I'm just hungry all the time. But anyways, no, I'll just be here eating and hoping baby Clyde comes in early January because I'm done with this. It's a lot.
Orlando asks, does this decision have any effect on any bar disciplinary proceedings against Willis? And I think the answer is no. And I don't know if there are any pending because those things are confidential, but I think we're in separate arenas. One would have no bearing on the other. Rachel, you got to.
Yeah, I'm not sure that there'd be any bar. I don't know of any bar complaints against her. I think there might be reasons, to have her behavior and decisions reviewed by the bar, but I don't know if it's worthy of being disbarred necessarily, even though I don't know. I mean, given what they've charged people with perjury and stuff for, it's just, I don't know. It's questionable. So if somebody wants to do that, anybody can file a bar complaint.
Well, Rachel, I want to say thank you for all your help this year.
Thank you.
This, barring any additional bombshell breaking news about this or anything else, this is probably going to be our last live stream here Inside the Law for the rest of the holiday season and New Year's. Tony, thanks for Tony's asking about the dissenting opinion. I want you to go read the dissenting opinion. We're not going to cover it here today. It basically says that the dissenting judge kind of didn't really disagree with a lot of stuff, just disagreed in the result. Basically would have deferred more to Judge McAfee and let Judge McAfee's opinion stand. In other words, he would give more deference to the trial judge. But I just didn't want to get into that whole thing because it could take quite some time. And Sea Travel, thank you so much for that comment, and thanks for being a member of the channel. This is probably going to be our last Inside the Law live stream, unless there's something really compelling that happens. I've got some things that I'm planning on doing. And like you mentioned, the last week or so has been particularly brutal. It seems like all the judges want to get everything done before they shut down for a week or two. And so with all the travel and things going on with the family, we're going to take a little bit of a brief hiatus to celebrate, the holidays here in the Holloway household. But I want to say thanks, of course, to Rachel and to all of you here who have supported this channel, who watch now and in the future. And do me a favor, if you haven't subscribed, please do so, and tell your friends and your family and anybody else who might want to learn something about the justice system. Where by necessity, we're going to have to move on because there's not going to be a lot of Willis news to get into, at least not that I'm aware of. YSL's over. In this case now is effectively over. We'll have to see what plays out, but we got other things that we will be talking about. And Rachel, I hope you'll come back and join us for all of that.
Happily. And I hope that you have happy holidays, and I'm sure I'll be in touch with you privately. And then when I have baby Clyde, I'll let everybody know.
Oh, we can't wait to meet Clyde.
Me neither. I can't wait.
Yeah, Clyde has an open invitation here Inside the Law. He's going to be a great legal analyst, I'm sure.
They say the baby can hear things, so he's been listening for all these months. He should know a few things.
He's well educated. He's ready for the bar exam on day one, right?
Thank you for everyone in the comments for your advice about pushing and breathing. I'm getting good laughs over here. Okay, Phil, we'll talk soon, and thank you for having me.
All right, big Inside the Law round of applause for our friend Rachel, colleague, great lawyer, great friend, colleague. And co-counsel of mine, actually, on a case or two now. So anyway, thanks to all of you guys for being here. I really appreciate it. And I want everybody out there to please be safe. Have a wonderful Christmas, Hanukkah holiday season, and a happy and safe new year. And with that, I'll sign off and say, until next time, I'll see you here back Inside the Law.